We'll start with the brief introduction. My name is Jolana Makrajova, and I'm the Senior Officer for Interdisciplinary Research with the Nuremberg Academy. We would like to welcome you all and thank you for your time to join us for the two-day event. Thank you in particular to all the speakers attending from various world ends and joining us at various times. We are very pleased to have you all on board discussing the topics. Thank you all attendees as well. We see a great number of participants already using the chat function and a public chat, and we welcome you all to the virtual courtroom 600, which is the room behind me, and is the history courtroom 600 where the Nuremberg trials took place in 1945 and 1946. Welcome to the first and exceptional Nuremberg Forum 2021 that is taking place over the virtual platform that I will briefly introduce before I give the floor to our director, Klaus Rackwitz. As we have mentioned in one of our previous communications, this year the Nuremberg Forum, due to the current ongoing pandemic, is taking place fully as an online event. It's spread over 2 days, and it's taking place today and tomorrow. We will start with opening remarks and introduction and keynote addresses this morning, and then we will move on to the substantive panel in the afternoon. The Nuremberg Forum objectives, despite the changes to the platform, remain the same. We would like to hear from experts and utilize an opportunity to reflect on the current ICL subject, hear from experts in the field, including their current challenges in the common fight against impunity and towards more sustainable peace through justice. We would like experts and all participants to share their observations and discuss development in the ICL, identify synergies and cooperation opportunities of ICL. We would like to focus on practical, expertise-based recommendation and innovative ideas towards addressing the raised and discussed challenges, fostering international criminal law. The way we are foreseeing this all to be done in 2021 is through an interactive platform. The platform includes everything that you need for the conference. It has the biographies, the program, and all are assembled under the nurembergforum.org website platform. The platform introduces the speakers, updates, and also looks at the past fora to connect the dots between various works that we've been doing. The foyer, which you joined after the registration, includes interactive chats. It has both the public and private chat. Please note that you can always deactivate the private chat if you are following the panel very closely or if you are participating in a panel itself. The public chat is for everyone to share their experience and also introductions from various ends of the world, as well as any relevance on the project. Please do maintain the respectful public space, ensuring that everyone feels comfortable to share their observations. We also have one-on-one meetings, which is available on our foyer as well. So during the breaks, we will encourage all the participants to join one-on-one meetings, to meet fellow colleagues and also other experts in the field, to interact and really advance one of the objectives of the forum. We also are very grateful to our partner, the Nuremberg Memoriam Nuremberg Trials, for partnering with us and allowing us to share the link for the courtroom 600 and the virtual platform, where you can see the courtroom in as realistic presentation as it is possible right now. We will also have a side event tomorrow morning with the research associate and the director of the memoriam, and they will both join us and explain the historical relevance and the developments within the courtroom 600. We also have scheduled 2 small rounds of About Us section, where we welcome you all to discuss our current projects where we might seek partnerships and initiatives, as well as highlighting the work that we've been doing over the past few years. Last but not least, we also incorporated a feedback section where we ask you all to help us develop our online platforms and online events and reflect on the Nuremberg Forum 2021, the likes, the dislikes, but as much as reflections on the interactive tools that you have been using and that were at your disposal, and the ones that really helped to make the forum much more a forum for dialogue rather than presentation itself. Now, turning to the substance, but very briefly, the Nuremberg Forum 2021 is planned as a two-day event, exploring the following two questions. First one, what is the framework enforcing the fight against impunity? Looking at the end goal of the fight against impunity. Is it the fight or is it the ending of impunity itself? Which systems are ensuring its compliance? The second question is, has the fight against impunity been living up to the Nuremberg Principles? What are the pertaining challenges in humanity's common fight against impunity or towards sustainable peace? What are the best practices that can bolster the fight against impunity in line with the Nuremberg Principles? The questions, as you can all imagine, are quite broad, and they will be interactive over the 2 days and will be answered in various forms and various questions. What is the ultimate goal in terms of substance is to really reflect whether the fight against impunity since 1915 has been living up to the Nuremberg Principles. It is, however, quite unfair for me to dwell onto the substance much more when we all have the privilege to have today with us the director of the International Nuremberg Principles Academy, Mr. Klaus Rackwitz, who has not only chosen this very important topic, but has been in contact with many of you in terms of tailoring the panels and the discussions towards addressing the very broad subject in a very interesting and also very pointy direction. Klaus is, as many of you know, the director of the International Nuremberg Principles Academy. He's a German jurist and a judge who has presided over criminal and civil trials in Germany. He has worked for the Ministry of Justice of North Rhine-Westphalia and became a member of the advanced team of the ICC in 2002. He has remained in The Hague as the senior administrative manager of the Office of the Prosecutor of the ICC for almost 9 years, and subsequently became a administrative director of Eurojust until 2016. In 2016, he took on his next challenge and moved to Germany to continue establishing and leading the Nuremberg Academy. It is with great pleasure that I give the floor to you, Klaus. Thank you very much.
Thank you very much, dear Jolana, and good morning, good evening, good afternoon, wherever around the world you are watching this event. Welcome to the Nuremberg Academy, and welcome in particular to the annual Nuremberg Forum, which this year indeed is, and hopefully for a singular time, only a virtual event. I can't thank Jolana and the team enough. They have worked tirelessly to set up this digital environment, and I hope it will all function. And I think we'll have a great conference, despite the fact that we cannot get together in courtroom 600, which is also my virtual background today. A few words maybe about the Academy. We are located in Nuremberg, as everyone knows, the birthplace of modern international criminal law. We have been established as a foundation by the federal government of Germany, the Free State of Bavaria, and the city of Nuremberg, which is worldwide known as the city of human rights. We do uphold the Nuremberg Principles and the rule of law, and we try to support the fight against impunity and the investigation and prosecution of core international crimes on all levels and in all areas. Three elements are the most important for us. One is capacity building in crisis and situation countries, as well as supporting newly established courts and tribunals in training and establishing knowledge with the practitioners. The second branch that we do is applied research. We look into contemporary issues that affect the work of prosecutors, judges, investigators, human rights activists, and many others. Some examples are, for instance, the role of modern digital evidence in the work of the courts, or the question about the length of the proceedings and how we can deal with this question, the use of private investigations, or how we can train social workers who are in contact with the refugees who very often are victims of mass atrocities. Now, the Nuremberg Forum is our annual conference, our main event, and it is actually the forum where practitioners, policymakers, civil society, and others meet in order to exchange critical sometimes, but always fair and balanced views. We are not an advocacy organization, but we advocate for the rule of law in general and on all levels. This neutral space that Nuremberg used to be at the beginning is for us a very, very important tool. What we would like to do now is these 2 days is to reflect on the question that Ilana has mentioned. What is it that we are looking for? Is it fighting impunity, or is it ending impunity, which of course has always been the end goal, to avoid future atrocities? But new crimes, new challenges come up. We have phenomena like terrorism, non-state actors, and many other things that did not exist when the Nuremberg Principles were established in 1950. And these recurring questions, terrorism is a good example, just picked up by the new ICC prosecutor, Karim Khan. How do we deal with this? And our forum is such a forum to discuss these matters and maybe to come towards a solution or even a progress in our daily work. What I would like to say before we go on into the substantial part of the conference, the Nuremberg Principles have never been formally signed in law. And I think this is a sad story, but they were in 1950, more than 70 years ago, established by the International Law Commission as a kind of a consensus among all states, among all cultures, religions, that the gravest crimes committed may not remain unpunished. And this means that the Nuremberg Principles today remain the beacon of hope for ending impunity and for justice for the victims and the survivors. I will later on introduce our 2 keynote speakers and the speaker of our opening statement in more detailed. Before that, what does the Nuremberg Academy do apart from this conference with regard to the Nuremberg Principles? Well, we have established a resource collection, which is, as far as I know, the greatest and largest online collection about material of the Nuremberg Principles that one can find available on our download area. Like all our books and publications, everything the Academy produces is open access. Now, in the morning program, we will have welcome remarks from our 3 founders. Then we move on to the opening statement from Professor Klaus Kress, and it is followed by 2 stellar keynote speeches delivered by Professor Teresh and Navi Pillai. Let me start with the welcoming remarks. And the first speaker is Dr. Christoph Eick, who is the legal advisor and the Director General for Legal Affairs of the German Foreign Office. He is also a chairperson of the foundation board of our academy. He was appointed to the position of Director General in 2018. He studied law in Bonn and Cologne, and holds a Master's of Law degree from McGill in Canada and a PhD from the University of Bonn. He is a career diplomat and in civil service in the Foreign Office since 1991. And it is with great pleasure that I hand over to Dr. Eick.
Ladies and gentlemen, good morning. 70 years ago, the International Law Commission adopted the Nuremberg Principles, summarizing the essential insights from the landmark Nuremberg trials in a concise set of normative guidelines. They have since become something like the DNA of our international criminal law system, and they have played a significant role in the development of modern international criminal courts. There could not be a more fitting starting point for a stock-taking exercise of how the fight against impunity has evolved over the last decades than marking the 70th anniversary of the Nuremberg Principles. I commend the organizers of this year's Nuremberg Forum for having chosen this perspective. It is a great privilege for me to address all of you on behalf of the Federal Foreign Office at the outset of this important and highly promising conference in Nuremberg or from wherever you may join us today. I would like to thank Director Rackwitz and the whole Academy for all the extensive work they have put into realizing this event. Over the past 7 decades, remarkable progress has been made in the field of international criminal responsibility. Before the Nuremberg trials set their precedents, Having government officials, especially heads of states, tried before international tribunals was largely a matter of only seemingly utopist proposals. It was only after the abhorrent crimes committed during World War II, in particular by National Socialist Germany, that the legal vision of international criminal justice became a reality. We have come a long way since then. Ad hoc tribunals such as the ICTY and the ICTR further paved the way for the creation of the first permanent international court with jurisdiction to prosecute individuals for the most serious crimes of concern to the international community as a whole. The undeniable achievements in the fight against impunity over the last decades are the fruit of the tireless efforts of countless people. Persons with a firm dedication to defend and advance international criminal justice. Lawyers, activists and journalists have kept up public pressure, often at their personal risk. In international fora, politicians and diplomats have continued to promote accountability. Prosecutors and judges have successfully tried highly complex cases, both at the international and at the national level. Nonetheless, 70 years after the adoption of the Nuremberg Principles, great challenges remain. Even in quite recent times, unspeakable atrocity has escaped international investigations and trials. It remains uncertain whether they will ever be addressed in a court of law. Almost 20 years after the ICC effectively came into operation, we should remain realistic. The court's scope is far from universal, with some of the major powers absent from the court. What is more, the court is facing financial difficulties and hostility in some corners of the world. Germany remains a strong supporter of the ICC, not only as second largest contributor to the court's budget. We also remain committed to improving the court and its mechanisms. This includes supporting the ongoing review and reform process to make the court fit for the future. I am confident that the coming 2 days will give us many insights into how the system of international criminal accountability has evolved and how it can and must be further improved. Let me extend my sincere thanks to the city of Nuremberg and to the Free State of Bavaria for their much appreciated support, and to the International Nuremberg Principles Academy for preparing this exciting event, and of course to all contributors and participants for their ideas and insight. I thank you.
Many thanks, Dr. Eick, for these welcome remarks on behalf of the Federal Foreign Office. We now continue with welcome remarks from our second founder, which is the Bavarian state, and it's a great pleasure to have with us the Bavarian State Minister of Justice, Georg Eisenreich. Studied law in Munich and is admitted to the bar since 2001. Since 2003, Minister Eisenreich is a member of the Bavarian State Parliament. He held the position of a State Secretary for Education, Science and Arts from 2013 to 2018, and he is appointed Minister of Justice on 12 November 2018. Minister Eisenreich, you have the floor.
Sehr geehrter Herr Direktor Rackwitz, sehr geehrte Damen und Herren, das Nuremberg Forum ist für die bayerische Staatsregierung, die bayerische Justiz und auch für mich als Justizminister von großer Bedeutung. Es war daher geplant, zur diesjährigen Tagung wie schon 2018 einen Staatsempfang auszurichten. Er sollte in der Kaiserburg Nürnberg stattfinden. Corona hat das leider verhindert. Ich freue mich trotzdem sehr, zumindest digital zu Ihnen sprechen zu dürfen. Im Rahmen von kriegerischen Auseinandersetzungen kommt es weltweit immer wieder zu unmenschlichen Verbrechen. Sie führen uns jedes Mal vor Augen, welch grundlegende Bedeutung die Nürnberger Prinzipien haben. Deutschland hat dabei aufgrund seiner historischen Vergangenheit eine besondere Verantwortung. Denn es waren die von Hitler-Deutschland begangenen Gräueltaten, die zum alliierten Militärtribunal von Nürnberg geführt haben. Hier wurden erstmals in der neueren Geschichte Politiker, Militärs und Funktionäre für staatliche Verbrechen mit den Maßstäben und den Verfahren des Rechts beurteilt. Es wurden dabei jene Nürnberger Prinzipien erarbeitet, die bis heute die Grundlage des Völkerstrafrechts bilden. Ohne diese Vorgeschichte ist beispielsweise der Internationale Strafgerichtshof in Den Haag nicht denkbar. Eine unabhängige Institution der Staatengemeinschaft, vor der sich Einzelpersonen für ihre Straftaten verantworten müssen. Aber auch das deutsche Recht sieht es vor, völkerrechtliche Verbrechen zu bestrafen. So hat der Generalbundesanwalt beim Bundesgerichtshof mehrfach Verfahren gegen Mitglieder der syrischen Regierung eingeleitet. Auch Mitglieder des Islamischen Staats und anderer Terrorgruppen wurden und werden in Deutschland strafrechtlich verfolgt. Damit kommt Deutschland seinen internationalen Verpflichtungen nach. Denn eins steht unumstößlich fest: derartig schwere Verbrechen dürfen nicht ungestraft bleiben. Die Verantwortlichen müssen für das von ihnen verursachte Leid zur Rechenschaft gezogen werden. Die konsequente Umsetzung dieser Grundsätze ist ein wichtiger Beitrag auf dem Weg zu einer friedlichen Weltordnung. Dieser kurze Abriss zeigt, es sind bedeutende und weitreichende Fragen, die auf Ihrer Konferenz diskutiert werden. In diesem Sinne wünsche ich Ihnen spannende und erkenntnisreiche Diskussionen.
Thank you very much, Minister Eisenreich, for these opening remarks. And it's with great pleasure that I turn now to the opening remarks of our third founder, which is the city of Nuremberg. And the remarks will be held by no one less than the Lord Mayor of the city of Nuremberg, Markus Konig, who became mayor of the city in 2020. Markus Konig graduated from Commercial College, has worked in the banking industry as financial advisor, and lastly as head of department in one of the largest German private banks. He is a member of the City Council of Nuremberg since 2008 and has worked in many, many honorary capacities, most notably in the Society for Christian and Jewish Cooperation here in Nuremberg. The floor is yours, Markus Konig. Thank you very much.
Sehr geehrte Damen und Herren, kaum eine Stadt in Deutschland steht antagonistisch stärker in Beziehung zu den schwärzesten Augenblicken deutscher Geschichte und den Bemühungen, diese Bürde zu tragen und die spezifische Erinnerungskultur dieses Ortes zu wandeln in ein Bild der Weltoffenheit, des Respekts vor den Menschenrechten und der Achtung des Gegenübers, wie hier in Nürnberg. Am 15. September 1935 wurden hier die sogenannten Nürnberger Gesetze beschlossen. Ein besonders perfides Zeugnis des menschenverachtenden Weltbildes des Nationalsozialismus. Die gesetzliche Grundlage für den systematischen Mord an Millionen von Menschen. Als Stadt der Reichsparteitage trägt Nürnberg bis in die heutige Zeit dieses auch architektonische Erbe, empfindet es aber gleichzeitig auch als Verpflichtung. Nürnberg unternimmt enorme Anstrengungen, meine Damen und Herren, um das ehemalige Reichsparteitagsgelände als zukunftsgewandten Erinnerungsort zu etablieren. Wir wollen die Bauten erhalten und entmystifizieren. Das Dokumentationszentrum Reichsparteitagsgelände ist dabei ein zentraler Ort der Erinnerung und Aufklärung. Meine Damen und Herren, die nachfolgenden Generationen sollen auch ohne direkte Zeitzeugen in Zukunft mit der Geschichte konfrontiert werden. Der Schwurgerichtssaal des Nürnberger Justizpalastes war nicht nur Schauplatz der juristischen Abrechnung mit einigen der hauptverantwortlichen Verbrechern des NS-Regimes. Hier wurden die Nürnberger Prinzipien manifest. Diesem völkerrechtlichen Meilenstein fühlen sich Stadt und Bewohner seither in besonderem Maße verpflichtet. An Aktualität haben diese Prinzipien nie eingebüßt. So ermuntert die prominente Anwältin Emil Clooney den UN-Sicherheitsrat während einer Debatte um die Verfolgung von Menschenrechtsverletzungen des IS in Syrien und im Irak eine historische Entscheidung zu treffen: Das ist ihr Nürnberg-Moment. Von Nürnberg, meine Damen und Herren, gehen viele Impulse der Menschenrechtsarbeit aus. In Nürnberg hat die Internationale Akademie Nürnberger Prinzipien ihren Sitz, wirkt in die Rechts- wie Zivilgesellschaft der Welt hinein mit dem großen Ziel der Pazifizierung als Auftrag. Das Memorium Nürnberger Prozesse bewahrt das Andenken an die Nürnberger Prozesse und Prinzipien. Und das Menschenrechtsbüro der Stadt Nürnberg vergibt im zweijährigen Turnus den Nürnberger Menschenrechtspreis und setzt die öffentliche Diskussion über Demokratiebildung, Diskriminierungsschutz und Menschenrechtsbildung auf die Agenda. Meine Damen und Herren, auch die Friedenstafel ist ein großes öffentliches Fest zu Ehren der Menschenrechtspreisträgerinnen und Träger. Es findet zwischen den Säulen der Straße der Menschenrechte statt. Diese Straße, gesäumt von Stelen, die das Postulat der Menschenrechte visualisieren, wurde vom israelischen Künstler und jüngst verstorbenen Ehrenbürger Dani Karawan geschaffen und 1993 eröffnet. Meine Damen und Herren, Nürnberg will heute eine Stadt der Weltoffenheit sein, in der alle Völker der Welt einen gleichberechtigten Platz finden. Nürnberg stellt sich dieser Aufgabe. Das Erbe der Vergangenheit wirkt in die Gegenwart und Zukunft. Nürnberg im Jahr 2021 steht für Vielfalt, friedliches Miteinander, Buntheit, Toleranz und Frieden. Das Nürnberger Forum ist die wichtigste Veranstaltung im Jahreskalender der Internationalen Akademie Nürnberger Prinzipien. Zum 70. Male jährt sich das Datum, an dem diese wegweisenden und für die Menschheit so bedeutenden Prinzipien erstmals formuliert wurden. Als Forumsteilnehmerinnen und Teilnehmer befassen Sie sich in den kommenden Tagen mit der Frage, ob der Kampf gegen Straflosigkeit in Einklang mit den Nürnberger Prinzipien von 1950 erfolgreich bestritten werden kann. Ja, leider, so muss man konstatiert werden, sind sie 70 Jahre nach der Formulierung der Nürnberger Prinzipien weiterhin mit dieser und mit ähnlichen Fragestellungen befasst. Dies zeigt jedoch, wie wichtig und wie notwendig und wie bedeutend Ihre Arbeit ist. Hierfür bedanke ich mich und wünsche Ihrem Kongress ein gutes Gelingen. Ihnen allen anregende und fruchtbare Vorträge und Diskussionen. Und das Wichtigste ist auch in dieser heutigen Zeit, bitte bleiben Sie gesund.
I thank the Lord Mayor of the city of Nuremberg, Markus Konig, very much for his opening remarks, and allow me to use this opportunity also to wholeheartedly thank all our three founders for their ongoing commitment to the Academy and to its work. Now it's with great privilege and also a pleasure that we welcome Klaus Kress here today for an opening statement in this conference. Professor Kress is a professor of criminal law and public international law, and he's the director of the Institute for International Peace and Security Law at the University of Cologne, which is also my own alma mater, I may say. Klaus Kress has served in the German Ministry of Justice, and he was a member of Germany's delegation to the Rome Conference in 1998. Professor Kress has written extensively on the use of force, the law of armed conflict, and international criminal law, and it's fair to say that Klaus Kress is one of the most exposed experts in the field of the crime of aggression. He was pivotal in the discussion on this crime in the review conference in Kampala in 2010 and also in 2017 during the ASP in New York, where this crime was activated. Klaus Kress is currently, and together with Navi Pillai, serving as an ad hoc judge in the case of the Gambia versus Myanmar before the International Court of Justice, and he has appeared as amicus curiae in the appeal of Jordan against the referral to the ASP before the appeals chamber of the International Criminal Court. With great pleasure, I welcome him. Klaus, the floor is yours.
Thank you very much, Klaus. It is both an honor and a pleasure to contribute the opening statement to this 2021 Nuremberg Forum. In the course of this forum, you will listen to contributions by leading experts in the field on a great variety of specific issues. Let me therefore use this opening statement to speak in more general terms, to pave the way for what follows, including two no doubt fascinating keynote speeches. Despite the generality of my statement, you will certainly recognize a certain emphasis on the national pillar of international criminal justice. Nuremberg marks an important law crystallizing moment. Before, the international legal order had been of an almost exclusively interstate nature. The Nuremberg judgment, however, introduced a concept which, for reasons of terminological clarity, is best be called international criminal law stricto sensu. This concept implies a jus puniendi that transcends the interest of one or more particular states. It is thus ultimately rooted in the international community as a whole. As a law crystallizing moment, Nuremberg did not appear as a bolt out of the blue. During the Paris peace negotiations after the Great War, the idea of and it was called that way, new international law, le droit international nouveau, including an international criminal law stricto sensu, was passionately put forward by France and by Great Britain, and welcomed by many others in view of the horrors of the Great War. But for its eventual breakthrough, it needed another outcry of the conscience of mankind and, crucially, the support by the Soviet Union and the United States at the end of the Second World War for the establishment of the Nuremberg Tribunal. Now, as Sir Hartley Shawcross, the British chief prosecutor, declared, the victorious powers stood united in their resolve, and he said, to defend and justify the innovation presented by the Nuremberg proceedings. And the United States Chief Prosecutor Robert Jackson made it crystal clear right at the opening of the Nuremberg trial that the intent behind Nuremberg was not to conduct these proceedings as an isolated ad hoc event. The determination was rather, as he proclaimed, to set a creative precedent designed for generalization. The ILC's 1950 Nuremberg Principles mirror and confirm that collective intent behind Nuremberg. The Commission recognized that the UN General Assembly had previously affirmed the Nuremberg Principles as principles of international law. Accordingly, Nuremberg Principle 1 embodies nothing less than the very concept of international criminal law stricto sensu. Quite a number of important criminal proceedings were conducted subsequent to those before the Nuremberg Tribunal. The same is true for subsequent proceedings to those before the Tokyo Tribunal, which had closely built upon the Nuremberg precedent. However, the Nuremberg Acquis, as well as the important addition of the 1948 Genocide Convention to it, had essentially been left dormant during the long decades of the Cold War. In practice, it was only in the 1990s that Nuremberg's potential for generalization was activated. When new outcries of the conscience of mankind led to the establishment ad hoc by the UN Security Council of 2 international criminal tribunals. Then, in the early hours of 18 July 1998, the rebirth of Nuremberg's and Tokyo's legacy in the 1990s and its development to a second generation of international criminal law stricto sensu culminated in the establishment of the ICC. In 1998, however, the Nuremberg legacy was not fully revitalized. While genocide, crimes against humanity, and war crimes had received their proper place in the ICC statute, the future of crimes against peace was left in limbo. It would take yet more than another decade until states parties convened in Kampala, and in the early hours of 12 June 2010 reached agreement about the definition of the crime of aggression. And only as from 17 July 2018, the ICC's jurisdiction over that crime is activated. As a result, the ICC is today entrusted with the power to exercise its jurisdiction about almost the entire substantive body of international criminal law stricto sensu. It is undeniable that for the time being, to borrow Robert Jackson's Nuremberg words, the political leadership in a significant number of states remains unwilling to concede that by joining the ICC statute, the power they hold would pay tribute to reason. Yet, the ICC, by virtue of the globally inclusive process of its establishment, the accession of a very large number of states from all continents, its standing invitation for universal accession, its jurisdiction over essentially the entire corpus of the international criminal law stricto sensu, and its institutional and procedural design in conformity with global human rights and fair trial acquis, possesses a credible universal orientation. In short, the ICC embodies the most advanced stage of centralization with respect to the enforcement of this community's jus puniendi ever reached in the evolution of international criminal justice. There will certainly be cases in the future, as there have been in the past, in which it is clearly preferable that the jus puniendi of the international community is enforced by the ICC or another criminal court with a credible universal orientation in the sense just mentioned. Yet, this will not necessarily be so in all instances. At times, proceedings conducted at the national level may have the most beneficial effect. Also, the historical experience has made it abundantly clear that for a variety of reasons, international criminal proceedings, including regional ones, do not present a practicable option. At present, the situation in Syria since 2011 provides an example that cries out. Therefore, the enforcement of the international community's jus puniendi, in order to be as comprehensive as possible, must continue to heavily rely on the national pillar. The Rome Statute recognizes and even emphasizes this reality. As a rule, it is preferable that national criminal proceedings take place in a state that is directly connected with a relevant crime or crimes under international law. Yet, it is state leaders who often bear the greatest responsibility for the commission of crimes under international law. In such cases, the state concerned may, as it were, be too directly connected with the crimes to offer the prospect of genuine criminal proceedings. History shows that this difficulty will not necessarily be overcome after a regime change in the country concerned. This is why the national pillar, in order to be effective, must include two principles that differ from the jurisdictional scheme of the classic international legal order. Both principles are implicit in the very concept of international criminal law stricto sensu. First, under classic international law, and the special case of the crime of piracy apart, states must be directly concerned with the crime to be in a position to exercise their national criminal jurisdiction over it. The situation is different in case of international criminal law, stricto sensu. For the criminalization of conduct directly under general customary international law articulates the global community's interest in the exercise of criminal jurisdiction. This means that each state may contribute to the realization of this community interest through the exercise of so-called universal jurisdiction. It bears emphasizing that due to the remoteness of the proceeding state from the crime in question, universal jurisdiction is not ideal. It should accordingly be exercised with caution and only on a subsidiary basis. Second, under classic international law, the conduct of a state organ acting in its official capacity was attributed solely to the relevant state. Under classic customary international law, this entailed the so-called functional immunity of state organs from foreign criminal jurisdiction. The criminalization of a conduct directly under general customary international law necessarily implies the departure from this traditional approach. For here, the individual is the direct addressee of an international conduct rule coupled with a criminal sanction. This articulates the resolve no longer to attribute the relevant conduct of a state organ solely to the state, but also to the state organ individually. Accordingly, Nuremberg Principle 3 articulates, in conformity with the Nuremberg judgment, that functional immunity under customary international law ends where international criminal law stricto sensu begins. Both universal jurisdiction and the inapplicability of functional immunity appeared fairly uncontroversial until the beginning of this century. But it is fair to say that both components of the national enforcement pillar have come increasingly under pressure. This is, as it seems, for two reasons. First, the world is currently experiencing powerful attempts at renationalization from various directions, and obviously for such political tendencies, international criminal law stricto sensu presents a central target. Second, In the wake of an increased activation of the national pillar after the Rome Statute's entry into force, the worry appears to have been growing that in view of the persisting deficiencies of many national justice systems, the power of universal jurisdiction might be politically abused. This worry is particularly strong with a view to proceedings against organs of a foreign state. If seen from the perspective of the Nuremberg Principles, these two reasons are of a very different kind. While the first runs directly counter to the thrust underlying the Nuremberg Principles, the second resonates with Nuremberg Principle 5, according to which any person charged with a crime under international law has the right to a fair trial on the facts and law. The current challenge thus consists of mobilizing resilience against the frontal attack on international criminal law stricto sensu, while duly considering the legitimate concern about political abuse of that body of law that cannot be ruled out. In order to meet this challenge, states are first called upon to firmly resist attempts to undermine the universal jurisdiction principle and the principle of the inapplicability of functional immunity. The elaborate confirmation by Germany's Federal Court of Justice of the latter principle in its recent landmark judgment constitutes a very significant example for such resistance. At the same time, however, Nuremberg Principle 5 should be developed through procedural safeguards specifically addressing the fair trial risks connected with universal jurisdiction and the inapplicability of functional immunity. Such safeguards should, for example, include ruling out trying the accused person in his or her absence, in absentia, and trying him or her for a second time in another state for the same conduct, ne bis in idem. One could be even more ambitious and introduce what could be called a system of accreditation. The power to exercise universal jurisdiction and to exercise jurisdiction over an official of another state for a crime under international law would then be granted only if an independent treaty body had before confirmed that the state concerned is equipped with an independent judiciary, both on the books and in practice. Understandably, the 1950 Nuremberg Principles do not explicitly address the multi-layered nature of the global system for the enforcement of international criminal law stricto sensu. But today, the International Law Commission will be well advised to emphasize the applicability of principles 3 to 5 on all levels of this global system: international, regional, national. Ideally, the International Law Commission could update the 1950 Nuremberg Principles through the addition of a new Principle 8. This could read as follows: proceedings for crimes under international law may be conducted internationally and nationally. Principles 3 to 5 apply to all such proceedings. The jurisdiction of an international criminal court is governed by its founding legal instrument. On the basis of the principle of subsidiarity, states may exercise universal jurisdiction over crimes under international law. This would be nothing more than an accurate codification of existing customary international law, and it would thus fall squarely within the ILC's mandate. I hope that my distinguished colleague, Professor Galvao Teresh, will consider this conclusion of my opening statement to be a convenient transition to her keynote. I wish you all a splendid 2021 Nuremberg Forum, and thank you kindly for your attention.
Dear Klaus, dear Professor Kress, thank you so much for your opening statement. This was already a great opening and a good setting of the scene. Let me now welcome our first keynote speakers, Professor Leticia Galvao Teresh, who is a professor of international law at the Autonomous University of Lisbon. And she's also a member of the United Nations International Law Commission. Professor Teresh is a member of the Permanent Court of Arbitration and is currently also the Vice President of the Portuguese Society for International Law. She's a researcher at the Center of International Law for the National University of Singapore and a co-director of the Singapore University E-Academy, Singapore Academy of International Law. At the International Law Commission, Professor Teresh was General Rapporteur at the 70th session in 2018 and chair of the drafting committee for the second session this year. And since 2019, she's the co-chair of the study group on the topic sea level rise in relation to international law. Professor Teresh, it's with great pleasure and an honor to have you here, and I hand over the floor for your keynote speech. Thank you.
Thank you so much. I am very honored to address the Nuremberg Forum 2021 today, and I thank the organizers for the invitation. I will be speaking about the contribution of the International Law Commission to the development of the Nuremberg Principles and its continuous relevance for the fight against impunity and the consolidation of international criminal law. The International Law Commission has had a seminal role over the progressive development and codification of rules in the fight against impunity since its inception. The end of the Second World War signaled the beginning of international criminal law, with the International Military Tribunal in Nuremberg and the International Military Tribunal for the Far East in Tokyo having convicted several individuals accused of crimes under international law. As soon as 1947, the United Nations General Assembly tasked the newly created International Law Commission, even before its members were elected, with the formulation of the principles of international law recognized in the Charter of the Nuremberg Tribunal and in the judgment of the Tribunal. In the same resolution, the UN General Assembly directed the ILC to prepare a draft code of offenses against peace and the security of mankind. Over its 72 years of existence, international criminal law and the fight against impunity have been part of the DNA of the International Law Commission, and since its very beginning, from the development of the Nuremberg Principles to the drafting of a code of crimes and a statute for a permanent international criminal court, and more recently with the draft articles on crimes against humanity. This is the journey I will attempt to describe briefly today as we mark the 70 years of the Nuremberg Principles. So let me start with the Nuremberg Principles. From 12 April 1949 to 9 June 1949, the ILC had its first session in Lake Sussex in New York. Entrusted by the GA, the ILC started its work on the Nuremberg Principles based on the memorandum of the Secretary General, which was entitled The Charter and the Judgment of the Nuremberg Tribunal, History and Analysis. This memorandum surveyed the work of the tribunal, as well as an account of the deliberations in the UN concerning the principles of international law recognized by the tribunal and its judgment. As recalled in the memorandum, during the first part of the session of the United Nations General Assembly in October 1946, the President of the United States and the Secretary General recognized that the Nuremberg Principles should be made a permanent part of international law. By the time the topic arrived to the ILC, the issue had been thoroughly discussed by member states in the GA and in its Committee for the Progressive Development in International Law and its Codification. From the outset, the members of the ILC faced the challenge of ascertaining whether the Commission should analyze to what extent the principles contained in the Charter of the Tribunal and judgment were principles of international law or not. The ILC concluded, on the basis of United Nations General Assembly Resolution 95, 1 of 1946, that it was not the role of the Commission to appreciate the nature of the principles, but rather to formulate them. So the ILC focused on the substantive articles of the Tribunal Charter, namely Articles 6, 7, and 8. Article 6 defined the crimes under the jurisdiction of the Tribunal, crimes against peace, crimes against humanity, and war crimes. Article 7 excluded the character of head of state or responsible officials of the accused as an element freeing responsibility or mitigating circumstance. And Article 8 established that the fact that the person accused was acting pursuant to orders of a superior does not free the former from responsibility. When the ILC considered the formulation of the Nuremberg Principles, it considered the question of whether, in formulating the principles of international law recognized in the Charter and the judgment of the Tribunal, it should additionally formulate the general principles of international law which underlie the Charter and the judgment. The member of the Commission, Georg at the time, advocated for the latter and presented a set of draft principles. This included the subjectivity of individuals under international law or the precedence of international law from domestic law, amongst others. While some of the principles enumerated by Sell did end up in the final draft, others were rejected by other members of the Commission, as it was considered that this enumeration was going beyond the scope of the mandate of the GA. Jan Spiropoulos was appointed Special Rapporteur by the Commission on the topic, as well as in the preparation of the draft code of offences against the peace and security of mankind. In view of the International Law Commission, the enumeration of the principles appeared to be so closely connected with that of preparing a draft code of offences that it sought to avoid giving a formulation on the principles before preparing a draft code. Based on the report presented by Spiropoulos, the ILC adopted the formulation of the 7 Nuremberg Principles in 1950. Principle 1 establishes the liability of individuals for international crimes. As corollary to this, Principle 2 reaffirms the responsibility of individuals regardless of the existence of a domestic criminal rule. Principle 3 considers the case of acts of other states and government officials as a fact that does not exclude criminal responsibility. Principle 4 excludes superior orders as an argument from the defendants for exclusion of responsibility. Principle 5 expresses the right to a fair trial. Principle 6 enumerates crimes punishable under international law, namely crimes against peace, war crimes, and crimes against humanity. And finally, Principle 7 added complicity in the commission of the substantive crimes as a basis for additional criminal responsibility. And these 7 principles were adopted, accompanied by an important explanatory commentary. When Resolution 499 of the GA invited states to make observations on the formulations of the Nuremberg Principles prepared by the Commission, certain states were in the view that the document was favorable, although they reserved their position regarding the future project of a draft code of offenses. Only a few countries, like Lebanon, for example, criticized the formulation of the Commission in line of what had been proposed by Georg, that the Commission should have developed principles of international law derived from the Nuremberg Charter, as it considered what the outcome was too narrow. Despite the discussions over the scope and mandate of the ILC's work on the principles, it is certain that the formulation produced by the Commission remains at the heart of contemporary international criminal law. In the end, one can say that the contribution of the ILC was to secure that the Nuremberg Principles were no longer considered in relation to the crimes of the Nazi government, but as universal principles. While the adoption of the Nuremberg Principles was rather swift, as we saw, the adoption of a draft code of offenses or an international judicial organ to trial persons for those crimes would take several decades of development. And I turn now to the question of a draft code of crimes and the question of international criminal jurisdiction. In parallel to the development of the Nuremberg Principles, the ILC considered the elaboration of a draft code of offenses against peace and security of mankind, with Jean Spiropoulos serving also as a special rapporteur. In the course of the preparations of the draft code, the ILC limited the scope of the instrument to offenses which contain a political element and which endanger or disturb the maintenance of international peace and security. The project included crimes similar or equal to the current definitions of act of aggression, war crimes, crimes against humanity, and genocide. The disagreement of states to find a commonly accepted definition for the crime of aggression in the dawn of the Cold War stalled any progress of the project after the version proposed by the ILC in 1954. Resolutions of the GA of 1954 and 1957 respectively postponed further consideration of the draft code until an agreement could be reached by the Special Committee on the question of the definition of aggression. The Special Rapporteur addressed the scope of the subject, the method that should be followed in the codification, and the question of whether to address the implementation of the code. In relation to substantive crimes, the new rapporteur excluded the political element as a requisite for the existence of an international crime. Additionally, the list of crimes considered in the draft code grew extensively. Article 19 defined in a declaratory manner a number of offenses considered to be international crimes: aggression, the establishment or maintenance by force of colonial domination, slavery, genocide, apartheid, and actions impeding the safeguarding and preservation of the environment. By the 9th report of the Special Rapporteur in 1991, the scope ratione materia was consolidated in aggression, threat of aggression, intervention, colonial domination, and other forms of alien domination, war crimes, genocide, apartheid, systematic or mass violations of human rights, recruitment, use, financing, and training of mercenaries, international terrorism, illicit trafficking in narcotic drugs, and willful and severe damage to the environment. In this sense, the draft no longer maintained the distinction between crimes against peace, war crimes, and crimes against humanity. But in 1994, based on the commentaries and observations of member states, the Special Rapporteur indicated its intention to limit the list of crimes to offenses whose characterization as crimes against peace and security of mankind was hard to challenge. And so in 1995, the ILC completed the second reading of the draft code, and only 6 crimes remain on the draft code, namely the crime of aggression, genocide, systematic or mass violations of human rights, exceptionally serious war crimes, international terrorism, and illicit traffic in narcotic drugs. In 1996, the ILC adopted the final text of the draft code with commentaries, having reduced the scope of the final document in order to reach consensus, but safeguarding the inclusion of certain crimes that did not affect the status of the other international crimes outside of the code. The final formulation of the crimes returned, in a sense, to the original one. It included the crime of aggression, genocide, crimes against humanity, crimes against United Nations and associated personnel, and war crimes. After the ILC recommended to the GA to select the most appropriate form to ensure the widest acceptance of the draft code, the GA expressed its appreciation for the completion of the final draft articles on the Code of Crimes and drew the attention of states participating in the preparatory committee on the establishment of an international criminal court to the relevance of the draft code to their work. And so let us look now how the ILC has contributed also to the creation of an international criminal court. From the outset of the discussions involving an international penal code, they were linked to the question of an international jurisdiction. As it was affirmed by the chairman of the Commission at its second session, Georg, in 1950, if such organ was not set up, what would be the point of defining the Nuremberg Principles? If, as a preliminary step, an international organ were created, there would be some chance of a real court of international justice being established, which would be competent to judge all war criminals to whichever side they belonged. And as early as 1948, the GA invited the ILC to study the question of an international criminal jurisdiction as a side debate of the adoption of the Convention on the Prevention and Punishment of the Crime of Genocide. Notoriously, at the time, the GA requested the ILC to pay attention to the possibility of establishing a criminal chamber of the International Court of Justice. At its first session, the ILC appointed members Ricardo Alfaro and Emil Sundstrom as special rapporteur. And in addition to working papers prepared by the rapporteurs, the Secretariat also presented the report with an historical survey of the question of international criminal jurisdiction. When at the second session, the ILC discussed the reports of the special rapporteurs, they addressed whether it was feasible and desirable to establish an international judicial organ or a criminal chamber of the International Court of Justice. As expressed by Sundstrom, the cons outweighed by far the pros. A permanent judicial criminal organ established in the actual organization of the international community would be impaired by the very serious defects and would do more harm than good. The time could not seem as yet be ripe for the establishment of such an organ. Both rapporteurs expressed concern over the possibility that a permanent court would carry the same criticism as the Nuremberg Tribunal as victor's vengeance and a respective application of the law. At the same time, they both agreed on the convenience of amending the Statute of the International Court of Justice for the constitution of a criminal chamber that could trial individuals. But despite this view of the special rapporteurs, several members of the ILC concluded that an international criminal court could be created by means of a convention open to signature by states, members and non-members of the United Nations without creating it as an organ of the UN. In this sense, while feasible, the ILC did not endorse the reform of the Statute of the International Court of Justice to create an international criminal chamber. In this line, the conclusions of the ILC led the General Assembly to create a committee composed by representatives of 17 states to prepare a preliminary draft convention for the establishment and the statute of an international criminal court. While the committee met in Geneva in August of 1951 and prepared the draft statute, the pause on the discussions on the draft code of offenses led to the stall of this topic as well. In 1954, the GA decided to suspend its consideration of the draft and also of the Code of Offenses until it received the report of the Special Committee on the question of defining aggression. And it was only when the GA invited the ILC to resume its work on the draft Code of Offenses in 1981 that the draft statute for an international criminal court resurfaced. The topic was touched upon by the report of the Special Rapporteur on the draft Code of Offenses, and the section of implementation of the code clearly stated that the questions of an international penal code and an international jurisdiction are closely interrelated. They are so linked together that neither can advance without the other. The report of TM expressed certain renewed skepticism over the creation of an international tribunal, however. Referring to publications of the time, Dudu Tiem picked a phrase that summarized his views, and I quote, "An international tribunal of the Nuremberg type is more an incantatory psychodrama than a really useful legal instrument." At the time, scholars criticized the role of an international court as superfluous and prioritized preventive measures. They argued that war crimes and crimes against humanity or peace have the force of a fait accompli, which makes any criminal conviction pointless. And that unless one wants to doctor the dead, the concern should be for prevention rather than the cure. And finally, it was argued also that the International Court would contravene the sovereignty of states and the principle of territoriality of criminal law as corollary of the forum. So based on these critiques and the lack of plausible alternatives in the short term, the IAM suggested the use of national courts to trial these cases or the states directly injured. The subsequent reports on the topic reflect these suggestions as they focus on the principle aut dedere aut judicare. In this sense, the work of the ILC was in line with international efforts of codification at the time, where several treaties regulated the suppression of crimes of international concern in areas such as drug trafficking, aircraft hijacking, and other crimes against civil aviation, etc. And these treaties were based on the idea that national courts should exercise jurisdiction over international crimes. And the idea of an international Nuremberg would not gain momentum later until the 1990s. And it was in that period when the ILC was requested by the GA in connection to the draft code of offenses to review the question of the establishing of an international criminal court or other international criminal trial mechanism. And in the 1990s, the ILC started again analyzing the topic based on the developments in international law. And it considered at that time that the establishment of an international criminal court was more feasible than when the matter was studied earlier. At that point, the Commission considered that a court established with a proper structure and safeguards could provide a better protection of procedural rights than the existing at the time system of universal jurisdiction based on national prosecution. For these purposes, the ILC assessed different possible models of constitution of an international court, including the possibility of a court with exclusive jurisdiction, a model of concurrent jurisdiction, and a court with a review competence only. By 1992, the Commission decided to establish a working group that would address the question of international criminal jurisdiction and would draft concrete recommendations. The working group agreed on a basic set of propositions. The International Criminal Court should be established by a statute in form of a treaty agreed by state parties. The court would exercise jurisdiction only over private persons, and the court's jurisdiction would be limited to crimes of an international character. Based on the constitution of the working group, the UN General Assembly requested the ILC to take the elaboration of a draft statute to undertake the elaboration of a draft statute for an international criminal court. And based on a preliminary draft and comments by states, the working group consolidated a draft statute in 1994 for the purpose of a future treaty. The elaboration of this draft statute of 1994 was what Professor James Crawford, who was the chair of the working group at the time, called the grandparent of the Rome Statute. He affirmed that this draft allowed to get the diplomatic ball rolling again after the stall of the 1950s and after. The GA welcomed the draft statute for an international criminal court together with its commentaries. And while after the diplomatic conference in Rome, there were many departures from the initial proposal of the ILC, it is certain that through these efforts, the work of the International Law Commission had a fundamental role on the adoption of the Rome Statute in 1998. So let me look now to conclude at recent efforts and challenges for the future. And let me highlight in particular the recent work of the Commission on draft articles on crimes against humanity. The International Law Commission has continued to have a fundamental role in the development of international criminal law and contributing to the fight against impunity. From 2005 to 2014, the International Law Commission entertained the topic obligation to extradite or prosecute aut judicare. The work of the Commission resulted on a report of the working group that intended to clarify the role of states and international cooperation in the fight against impunity based on the Nuremberg legacy. The International Law Commission has also been working on a set of draft articles on immunity of state officials from foreign criminal jurisdiction. Although this work is not yet finished, these draft articles contain an important provision, which is draft Article 7, on exceptions regarding immunity ratione materia concerning international crimes. And let me here make a parenthesis on a personal basis to say that I take good note to what was said by Professor Klaus Kress in his statement just a few minutes ago. In 2013, the International Law Commission also identified the need to incorporate the topic of crimes against humanity on its program of work. The Commission considered that the three core international crimes, crimes against humanity, war crimes, and genocide, only the last two had been subject of multilateral treaties for the prevention and punishment of these crimes. And considering the prevalence of crimes against humanity, the International Law Commission decided to address the development of a draft convention to enhance the prevention and punishment, as well to include other issues that were not covered by any existing treaties. Under the very able leadership of Professor Sean Murphy, who was the Special Rapporteur on Crimes Against Humanity, this project received solid support and a record number of comments and contributions. In 2019, the International Law Commission adopted in second reading the draft articles on prevention and punishment of crimes against humanity, containing a draft preamble, 15 articles, and an annex. The topic is under current consideration of the 6th Committee of the GA, and as we speak, there are negotiations going on regarding this topic. Hopefully, consensus will build towards the negotiation of an international convention, thus consolidating one more important contribution of the International Law Commission to the fight against impunity that started 70 years ago with the adoption of the Nuremberg Principles. I thank you for your attention.
Thank you so much, Professor Galvao, Teresh, for these inspiring words. This really was fascinating to listen to you and the broad range of topics you have discussed. I'm sure we will come back to some of them in the course of our forum today and tomorrow. Now, it is my distinct pleasure to announce the second keynote speaker of this morning, Dr. Navi Pillai, who is the president of the Advisory Council of the International Nuremberg Principles Academy. She has had so many important functions that it's almost impossible to list them all. She was the High Commissioner of the United Nations High Commission for Human Rights. She was a judge and the president of the International Criminal Tribunal for Rwanda, and she has served as judge also at the International Criminal Court. She was the first South African who was awarded with a doctor's degree at Harvard University. She was the first female African origin judge in South Africa after the end of apartheid, and was appointed to the Supreme Court of South Africa, and subsequently then the international career. She is still extremely active. She's serving as an ad hoc judge before the International Court of Justice in the case of the Gambia versus Myanmar, and she is also involved in many other activities. She has published extensively, and it's fair to say that she's one of the most experienced persons around the world in international criminal and humanitarian law. It's really a pleasure to have you with us for a keynote. Navi, the floor is yours. Thank you so much for being with us.
Thank you very much, Klaus. Sorry for that short delay. Thank you for your kind remarks and my very warm greetings to all those attending this forum. I've been asked in this second keynote address to look at the fight against impunity from my personal point of view. And so I would say that the years 2020 and 2021 are truly appropriate to reflect on the 70th anniversary of the Nuremberg Principles, the Nuremberg legacy, and my still unwinding path as a human rights defender and pioneer, not only because of the many commemorations, including this one and last week's marking the 75th anniversary of the International Military Tribunal judgment, but also because of, firstly, my current thinking on the work that remains to strengthen accountability for core international crimes and to achieve equality. And secondly, my own contributions thus far and the lessons I feel compelled to share from my own experience, reflecting on the path going forward. I have over the years, and most recently in my CNN op-ed, urged that we must demand accountability and continue pushing towards ending human rights violations everywhere. Otherwise, they are likely to be repeated anywhere. Our work is not yet done. On that note, I would like to share a personal reflection on the lessons of Nuremberg and my thoughts on the fight against impunity since at least 1945. The 7 Nuremberg Principles have been described by Klaus Rackwitz, our director of the International Nuremberg Principles Academy, as a beacon of hope worldwide. They encapsulate the idea that any person committing a crime under international law can be held responsible, that crimes can be legal under domestic law and still illegal under international law, and perhaps most importantly, that heads of state and government officials can be held responsible and cannot claim immunity if they were ordered to commit crimes. Finally, the principles reinforce that any person charged with an international crime has the right to a fair trial. There are more, so therefore I would say, Klaus, they are more than just a beacon of hope. The wealth of guidance the principles provide is evident in their impact on the trajectory of international criminal law over the subsequent 7 decades, of which the Nuremberg Academy's resource collection is a valuable treasury. I am pleased to be associated with the Academy's effort to collect these resources for future generations. These lessons must not be lost. They include, from these principles, any person is responsible and liable to punishment, Principle 1. The fact that internal law does not impose a penalty does not relieve the person who committed the act from responsibility under international law, Principle 2. Act upon the title of head of state or responsible government official is no bar from assuming responsibility under international law, Principle 3. And superior orders are also irrelevant when it concerns responsibility under international law, Principle 4. So in simple terms, the Nuremberg Principles define impunity as the absence of accountability, in particular for the core international crimes, crimes against humanity, war crimes, crimes against peace, and genocide. And Nuremberg was a milestone in the effort to link the achievement of sustainable peace to justice. So let me now turn briefly to address the meaning of the words fight against impunity. The end of the Cold War in the 1990s unleashed an age of accountability and the rise of anti-impunity discourse. We have witnessed, as examples, the arrest of Slobodan Milosevic of the former Yugoslavia, the prosecution of Augusto Pinochet of Chile, and the creation of the ad hoc tribunals mandated to prosecute persons responsible for serious violations of international humanitarian law in the former Yugoslavia and Rwanda. We have witnessed the codification of key international standards, including the UN set of principles for the protection and promotion of human rights through action to combat impunity, based on the moral claim that the individual human being, as a citizen of the world, should be the law's primary concern, and that harm done to that individual constitutes harm to the community so grave and outrageous that it must not go either unnoticed or unpunished. And we have seen a collective push to provide a roadmap to true accountability, including trials, truth-seeking exercises, reparations, and institutional reforms to organize the transition from impunity to accountability. These mechanisms draw the line between individual harm and the wider impact of that harm, and why justice for the affected community matters as well. I have seen great work accomplished towards devising that roadmap using the Nuremberg Principles. The International Criminal Court's establishment is a remarkable achievement of which I'm also personally very proud. But we still cannot fail to notice the great uncharted areas that remain, the spaces where our aspirations have not made a mark on the experiences of traumatized victims and communities. Violence and instability is what many people today still have to navigate. We cannot say that the Nuremberg legacy has been upheld until the Nuremberg Principles are a lived reality for all victims. I would like to highlight 4 questions for this forum's consideration. 1, is the accountability framework now in place a reason for celebration? 2, are international criminal law and international justice the same? And 3, how are core international crimes changing the landscape of international criminal law? And 4thly, has the fight against impunity been living up to the Nuremberg Principles? Now, regarding the first question, I celebrate the development of the accountability framework, both in terms of substantial and procedural international criminal law. This includes the focus on crimes of sexual and gender-based violence, among many other advances. As ICTR judge and president, I had the unique privilege of adjudicating the first groundbreaking cases against the interim Prime Minister, John Kambanda, and other political, military, and religious leaders, resulting in the world's first conviction, in the case of John Paul Akiesu, mayor of Taba Commune, of the crime of genocide, and specifically for rape and sexual violence as crimes of genocide. Akiesu's conviction is an important signpost on our roadmap, as are the convictions of former Liberian President Charles Taylor, former Bosnian Serb leader Radovan Karadzic, Congolese warlord Thomas Lubango Diallo, and former Chadian President Hissène Habré. These bright lights illuminate what is possible when we work diligently to reconcile the often conflicting demands of international law and national sovereignty. The Special Court for Sierra Leone convicted Charles Taylor of planning and aiding and abetting the commission of crimes against humanity in the neighboring state of Sierra Leone. The ICTY convicted Radovan Karadzic of genocide for the massacres of Muslims in Srebrenica. The International Criminal Court entered its first conviction against Thomas Lubango Diallo for the crimes of forcible recruitment and use of child soldiers. And in a critical exercise of universal jurisdiction from Senegal, Hissène Habré was convicted of war crimes. These are all significant steps forward in holding high-profile perpetrators of crimes accountable. I celebrate the various codes and treaties that shape the international legal order, including but not limited to the Convention on the Prevention and Punishment of the Crime of Genocide of 1948, the Universal Declaration of Human Rights of 1948, the Geneva Conventions, 1949, the European Convention on the Protection of Human Rights of 1953, and the African Charter on Human and People's Rights of 1981, to name a few. We might take these laws for granted now, but as the exemplary struggle of Raphael Lemkin to codify genocide demonstrates, these advances in the law are not guaranteed to us, but must be hard-won. Lemkin stands in for a good number of lawyers and diplomats whose names we may not know, but whose life's work has changed our lives for the better. The life's work of Ben Ferencz to criminalize aggression in modern law, or of Leila Sadat to further codify crimes against humanity, are both examples that this work is not yet finished, nor has it gotten easier with time and practice. These accomplishments are great milestones. They have come with great persistence and the dedication of many lives' work to the cause of achieving a more just world. We must persist in advancing against the challenges that we are currently facing. We must know the territory we seek to map. We must not become discouraged by the inevitable obstacles, and we must be ready to pick up the standard of those who came before us and to carry it forward. We are the living legacy of Nuremberg. We are the cartographers of our own map, as incomplete as it may be. The challenges we face are not just normative, but also practical. A good example is developing an independent investigative body or bodies that strengthen the current system. We have advancing technology that is fast developing, and we cannot always predict how it will affect our work, for good or bad. Standardizing knowledge transfer, archival of information, and strengthening cooperation between various actors are representative of what we hope to leave behind, a community committed to advancing the law, able to liaise with itself in harmony and to comprehend what has come before and build on it. Let me now turn to the second question I raised. Are international criminal law and international justice the same? We should never be satisfied with our knowledge of the objectives, goals, and aspirations of international criminal law, and in defining what international criminal justice actually means. The landscape of international law is constantly changing, as Professor Klaus Kress has highlighted. This is in part because the Nuremberg Principles have been developed and implemented within the wider historical development of the United Nations, of various codes entrusting sovereign states to execute their obligations of prosecuting and punishing or extraditing individuals, and of numerous other efforts to address growing inequality between people, such as the creation of the Sustainable Development Goals and the 2030 UN Agenda Roadmap. We are not the only ones grappling with both the historical and contemporaneous impact of impunity. A challenge that I see is to accept that these objectives, goals, and aspirations may conflict, and that we must find a collaborative way forward. A dialogue towards that end should be explored whenever varied goals interact. We don't all see the world through the same lens. We must keep reflecting, keep building that dialogue, and keep realistic expectations. Understanding each other is not just a means to an end, but an end in itself. Now, the third question, which is a correlated issue, and that was, how are core international crimes changing the landscape of international criminal law? There has been great progress in formulating and shaping the core international crimes. Sorry about that. Now, as I said, there has been great progress in formulating and shaping the core international crimes and related modes of liabilities. Without these, there is no foundation for the concept that international peace and security relies on the elimination of specific criminal activities affecting individuals and their communities. There are increasing appeals to add certain crimes under the umbrella of core international crimes. Arguments include the need to reflect on the current realities of the common fight and grave violations occurring worldwide, and our moral obligation to protect all of humanity. These arguments also reflect a growing belief that respect for and protection of our natural environment is essential to protecting the people who shelter within it. On the other hand, arguments arise with respect to preserving the Nuremberg legacy and effectively ranking those crimes addressed at the International Military Tribunal as the most heinous crimes that address or impact the community as a whole, and therefore permanent priorities for the international community. Given the evergreen call for efficient usage of limited resources, this question is a practical as well as a moral or theoretical one. This year's forum will look at both of these issues, reconciling the contrasting objectives of international criminal law and international justice, and looking into the question of core international crimes. So the last question I posed, posed by this forum actually is, has the fight against impunity been living up to the Nuremberg Principles? And my simple answer is yes, but that fight is not done. We have great achievements in our common fight against impunity to uphold the Nuremberg Principles and wider legacy. Here, first, nobody under the law is above the law, not even heads of states when it comes to international crimes. We have understood that political power can be a safe haven for impunity and can create a dangerous double standard for accountability. We have advanced our aspirations for equality. Second, anyone can be held to account for their actions. And thanks to universal jurisdiction principles, this can happen almost anywhere. Third, we know and we are aiming for a peaceful world order, an international order based on the rule of law. However, we miss more detailed or systematic reflection on the rule of law system or system enforcing the Nuremberg Principle and assessing its effectiveness. We need to understand why we have increasing conflicts worldwide, despite the safeguards, treaties, rules, and international standards in place. We need to agree on the additional set of rules and norms that may be missing from this legal framework. We need to start thinking about effectively addressing the challenges that are before us, or we can confidently predict will soon be before us. We need to strengthen the system to gain more political goodwill and effective cooperation. These are a few personal reflections on the given topic within the limited and allocated time given. But before I conclude, I would like to restate the importance of this forum and our dialogue. This forum seeks to take a look back and to take stock of one, how much the vision and aspirations behind creating and formulating the Nuremberg Principles have been fulfilled. Two, the characteristics and status quo of the systems and structures that have been set up since post-World War II that strive to fulfill or enforce the Nuremberg legacy, including highlighting challenges that persist. And thirdly, to look at what else can be done to strengthen the rule of law, to achieve the aspirations of the Nuremberg Principles, translated today to achieving sustainable peace through justice. I hope I have provided some initial thoughts for reflections and further discussions. Please join the discussion and reflect with us on the key topics and propose recommendations and practices that worked in your experience and help us advance the debate. I particularly welcome the timing of this forum, considering it has been 1 year since marking the 75th year of the start of the International Military Tribunal trials in Nuremberg. That commemoration led to poignant and powerful reminiscence of the trial itself and aptly shed light on the status of the fight against impunity today. I would also like to recall my recent appeal published on CNN. I am 80 this month, and as I keep up the good fight, I encourage you to do the same. There's always more we can do to support one another, to support the communities we care about, and a world that deserves justice for everyone. The path towards implementing the Nuremberg Principles is a symbol of humanity's aspiration and progress towards justice. We are morally obliged to continue our collective work towards a more just and peaceful future on behalf of the next generations. We must move away from a culture of impunity for egregious crimes and gross human rights violations towards a culture of accountability and responsibility. This is the essence of Nuremberg, and it is central to the legacy that I too hope to leave behind. Moreover, it is crucial for governments to recognize that a world which repudiates fundamental human rights, that retreats from established standards, undermines the rule of law, and fails to deliver justice to victims of serious crimes, is a world which will be less secure and more vulnerable to devastating conflicts. My continuing hope for a better world is sourcing from the following achievements over the last few years. One, we have witnessed the workability of the accountability framework. For instance, in the arrest of heads of states. Two, we have witnessed acquittals, thus strengthening the rule of law system. Thirdly, we are witnessing more and more demands for accountability, including national prosecutions and deferrals, and creative ways of achieving accountability in cases of political obstruction. These are just a few critical steps up the path, which reaffirm my long-held belief that if we are to achieve our goal of ending impunity, we need collective action by all, by governments, the private sector, and civil society. This is my roadmap to you. I hope you will take it up with the knowledge that we are investing in the coming generations to get us further up the path to a truly peaceful and equitable world. Let us take some collective action today and discuss these issues proactively over the next 2 days. I would like to thank you, Klaus Rackwitz, for convening this forum on this important subject of ending impunity for serious crimes and living up to the Nuremberg Principles. Thank you.
Dear Navi, thank you so much for these inspiring words. and you raise such a wealth of topics and issues to be discussed that I'm afraid maybe a 2-day conference is not even enough to do so. I'm pretty sure that your address has raised many thoughts and discussions, and I wonder whether maybe someone would already like to reflect. Patricia, did I understand it correctly that you would like to respond briefly or make a comment on Navi's speech? And also Klaus, of course, would be more than welcome to do so. Fortunately, we have enough time, so there is no need to rush. But I would start with Patricia first, please.
Thank you so much, Klaus. This is really a privilege to be part of this such inspiring opening panel for the conference of today and tomorrow. And I wanted also to echo what is for me the main message, and something that certainly the other panelists throughout today and tomorrow will be discussing. For me, the international criminal justice is a system, and it's a system that has today the International Criminal Court at the center, but certainly is a system that also has to be completed by, as Klaus Kress said, at the national and the regional, but especially the national level. And that element of the international criminal justice system is extremely important. I think the ICC was certainly not designed to try everybody everywhere, but the most responsible for the most serious crimes. But we need also to strengthen the national jurisdictions for that purpose. And of course, the question of universal jurisdiction continues to be of extreme relevance, and also instruments. And that's why I've emphasized at the end of my statement, instruments such as possible, and I hope one day we'll have a convention on the prevention and punishment of crimes against humanity, because that's a tool also at the horizontal level to strengthen the fight against impunity. And the other point, which was a point that I just very briefly reacted impromptu in my speech to what Klaus had said, and something that we've been also discussing for some time now, and it's a very important topic that it's before the International Law Commission on the immunity of officials from foreign criminal jurisdiction, because here also there's the importance of defining what are the limits to that immunity, especially when it comes to serious international crimes. And I think that's going to be another extremely important element of this international criminal justice system. So it's very important that we work hard. This is a topic that has been at the Commission's agenda for quite some time now. It's been a difficult topic. It's a sensitive topic. Navi Pillai has also explained well why these issues are difficult at the current political moment. But it's important. It's not, I think, also from what we heard in all statements, including what I tried to describe in the work of the Commission, it's really not a linear evolution. It's an evolution that has advances, and then it has it recesses, but then it has advances again. So I think we have to look in the long term and think that in the long term this will be an improvement to what we have, although it's not going to be linear. So I also really think that the work that the Commission is doing with regard to the topic of immunity of foreign criminal jurisdiction of state officials is an important part of the process, and hopefully we'll be able to conclude the topic in the short term. I don't know exactly when, but in the short term. But I think that is going to be an important part of the process with the affirmation of the non-application of immunity ratione materia for serious international crimes. So those would be my comments. And again, such an honor to be part of this initial panel with such esteemed panelists and colleagues. Thank you so much.
Thank you, dear Professor Galvao, Teresh. And now I would like to hand over again to Professor Klaus Kress. Klaus, the floor is yours.
Thank you, Klaus. And as you said, I thought we have been listening to two fascinating keynote speeches, as was to be expected, when Patricia and Navi would be the speakers. And I think, Navi, you have set the tone precisely right. I share your basic sentiment, which is a balanced one, that on the one hand, we have reason for contentment and even, as you said, celebration. As regards the point that has been reached, which I would summarize as a normative edifice that has taken an unprecedented sophistication and scope, and also a practical impact which justifies to say that international criminal law as practiced now is a firm part of the international landscape and has begun to shape it. I believe this is reason to be content and to celebrate. And on the other hand, you have very rightly emphasized the existing, continuing challenges, and also that certain challenges as a result of a change of the overall climate, world climate, might have even become greater, and that it is only realistic to recognize this. In terms of those challenges, I think in both keynote speeches, the different levels have already been quite accurately foreshadowed and fleshed out for the debate in this forum. The normative level, you have both referred, and of course Patricia in particular, as the ILC has done so important work. Probably the draft on crimes against humanity is the single most important normative document which could add in the short or mid-term perspective to the international legal edifice. There is, as you all know, this very interesting and stimulating proposal on law against ecocide on the horizon, which is perhaps in terms of conceptualization a step still a bit more distant than the draft on crimes against humanity, on which so much work led by Laila, Sadat and others has been invested. So there are important normative challenges, but perhaps this is not the most important one given the stage that we have reached. In terms of practice, you have both referred to the fact, and it was said in the welcoming addresses as well, that we are in an interesting and ongoing process as regards the ICC of further improving the structures, never be content with what we have reached so far. And I would also point to the national level, and just speaking as a German scholar, to give you a sense of what we are confronting in Germany now. I think we can say that we have a reasonably well fleshed out normative structure for universal jurisdiction, our Code of Crimes under international law. And this has been brought to practice in the emerging Syrian trials. But when doing this, in the process of doing this, we have recognized new challenges that had not been so apparent that far. And I give you just one example. How to accurately convey that those trials are underway to the world, to convey this beyond Germany, to allow victims to have a meaningful part and to make people in Syria aware of what is happening. And there are very practical questions involved, such as translation. not just to the immediate participants, but to the wider public. If international criminal law, international criminal justice has an expressive function, as I think the two of you, Patricia and Navi, would agree it has, then we have to work on satisfactory practices to make this function happen. And third and last, and that's the point to which I return from my own little intervention, we have to continue, and that's rather the political level. This is something where scholars may play a helpful role, but ultimately they are not decisive, but it is an appeal to decision makers. We have to continue working against persisting double standards in international criminal justice. And then perhaps the single greatest challenge, we have to build up as much as we can. States, supportive states have to do this. Resilience against powerful attempts to roll back, to retreat from the point that we have reached. It's not just about further sophistication, progress, but it is also that we have to be realistic that there are powerful forces now, and perhaps more than in the decades of the 1990s and the beginning of this century, that would like to see less international criminal law than at present. And here I think states are at center stage to mobilize the resilience that is necessary in order to make the fundamental goal of this forum, Klaus Rackwitz, to continue to be a realistic one. Thank you.
Thank you very much, and I think we all have to agree with you on one fundamental issue. What has been achieved cannot be taken for granted for the future. It needs day-to-day engagement, it needs a constant engagement, it needs power, and it needs sometimes creative approaches to indeed preserve and expand what we do have in the field of international criminal law. And that would not be possible without scholars, practitioners like all three of you are, who are in the forefront of this discussion and who keep up the presence of the danger that what has been achieved can also be easily lost. I can't thank you enough. It is actually a part of our motivation to continue our work in this support and in the strengthening of international criminal law, and that would not be possible without you. So again, very, very grateful to your contributions to this and this opening of the forum, which has raised so many pertinent issues on which we sure will all come back, and I'm really looking forward to the discussions in the panels this afternoon and tomorrow. Thank you so much, and I hope I see you again very soon, also in person and not only virtually. Thank you so much. And I hand over back to Jolana. Thank you.
Thank you, everybody, and thank you for the very inspiring, welcoming addresses, opening statement, and keynote addresses. Thank you all for listening to us and joining us and engaging on a platform. I know that there have been some technical difficulties, so please always look for the news and updates, as the communication channel with our technical team is directed through that. And now we are scheduled to have a tiny break, which is going to last 1 hour, but it's not 1 hour break. We do have many interactive sessions that I, again, encourage you to try and experience, including the one-on-one session. And at 12:15, we will have our colleague, Eduardo Toledo, opening a brief session about us, where you can ask questions about our work and plans and projects that are ongoing at the Academy. And the next panel is going to be panel 1, focusing on the historical perspective and dedicated to reflecting on the post-war setup and the status quo today. We will be joined by 2 excellent historians discussing the various frameworks being set up in the post-conflict situation country. And we do encourage each one of you to ask questions. So please do send us the questions. I know that the chat is a bit confusing, but you can directly set the question under the private chat, which we will receive and we will convene to the speaker during the presentation. So thank you again on our behalf, and we will see you and we will reconvene back online at 1 o'clock.